Provision that the criminal proceeds or substitute proceeds of the racketeering would be forfeited under state law, and the Attorney General has given notice that there is no property that was used in the course of, intended for use in the course of, derived from, or realized through the racketeering conduct alleged herein that is subject to forfeiture. Further, Mr. Chatfield, in count 2, you are charged with the crime of embezzlement from a non-profit organization in the amount of $1,000 or more, but less than $20,000. That is a felony that is punishable by up to 10 years and or $15,000 or 3 times the amount embezzled, whichever is greater. A consecutive sentence may be imposed for any other conviction if the embezzlement victim was a nonprofit, a person 60 years of age or older, or a vulnerable adult. To impose a fine of 3 times the value, the defendant must admit to the amount, or it must be determined by the trier of fact at trial. Similarly, in count 3, you are charged with the crime of conspiracy to commit embezzlement from a nonprofit organization, $1,000 or more, but less than $20,000. That is a felony punishable by up to 10 years and or $15,000 and a $10,000 additional fine. In count 4, you're charged with embezzlement from a nonprofit organization, $1,000 or more, but less than 20. Again, a felony punishable by up to 10 years and or $15,000. And the consecutive sentence provision applies here. In the alternative to that count, in count 4, you're charged with the crime of larceny, $1,000 or more, but less than $20,000, which is a felony punishable by up to 5 years and or $10,000, or 3 times the value of the property stolen. In count 5, you are charged with embezzlement from a nonprofit organization, $1,000 or more, but less than 20. Again, a 10-year felony and punishable and or by $15,000 or 3 times the amount embezzled, whichever is greater. In the alternative to that count, you're charged with larceny, $1,000 or more, but less than 20, a 5-year felony and or $10,000. In counts 6, 7, and 8, you are similarly charged in the alternative, first with embezzlement, $1,000 or more, but less than $20,000, which is a 5-year felony and or $10,000, or 3 times the value of the amount embezzled, whichever is greater. A consecutive sentence may be imposed for this conviction if the embezzlement victim was a nonprofit, a person 60 years of age or older, or a vulnerable adult. In the alternative to that, in count 6, you're charged with embezzlement again of $1,000 or more, but less than 20, 5-year felony or $10,000. In the alternative to that, you are charged larceny, $1,000 or more, but less than 20, which is again a 5-year felony and or $10,000. In count 7, embezzlement, $1,000 or more, but less than $20,000, which is a 5-year felony and or $10,000. And in the alternative to that count 7, larceny, $1,000 or more, but less than $20,000, a 5-year felony and or $10,000. In count 8, embezzlement, $1,000 or more, but less than $20,000. Or in the alternative, larceny, $1,000 or more, but less than $20,000. In count 9, 10, and 11, Mr. Chatfield, you're charged with the crime of embezzlement by a public officer over $50. And those are felonies punishable by up to 10 years and or $5,000. And then in count 12, you are charged with embezzlement from a nonprofit organization, $1,000 or more, but less than $20,000, a felony punishable by up to 10 years and or $15,000. And in count 13, you are charged with the crime of Charitable Trust Act felony violation. And that is a felony punishable by up to 5 years in prison and or $20,000. Mr. Chatfield, Do you understand these charges and the maximum possible penalties?
Yes.
Thank you. And now turning to file number 24-247FY with Stephanie Chatfield. Ms. Chatfield, I want you to know that you are charged in this felony complaint in count 1 with embezzlement from a nonprofit organization, $1,000 to $20,000. And the complaint alleges that between the dates of December of 2017 to April of 2021, you did commit that crime, which is a felony punishable by up to 10 years and or $15,000, or 3 times the value of the embezzled property, whichever is greater. A consecutive sentence may be imposed under state law if the embezzlement victim was a nonprofit, a person 60 years of age or older, or a vulnerable adult. To impose a fine of 3 times the value, the defendant must admit to the amount or it is determined by the trier of fact. In count 2, Ms. Chatfield, you're charged with the crime of conspiracy to commit embezzlement from a nonprofit organization in the amount of $1,000 to $20,000, and that is a felony punishable by up to 10 years and or $15,000 and a $10,000 additional fine. Ms. Chatfield, do you understand those charges and the maximum possible penalties?
Yes.
Mr. and Mrs. Chatfield, I want you to know that you have a right to an attorney. And if you can't afford an attorney, one will be provided for you at public expense. The court has received appearances from Ms. Chartier on behalf of Lee Chatfield and Mr. Newberg on behalf of Stephanie Chatfield. Mr. Chatfield, do you understand your right to an attorney?
Yes.
And Ms. Chatfield, do you understand your right to an attorney?
Yes.
I also want you to know you have a right to a trial. And at that trial, you would have many rights available to you. First, Ms. Chartier, have you and Mr. Chatfield had the opportunity to review his trial rights?
Yes, we have, Your Honor.
Okay. And Mr. Newberg, have you and Stephanie Chatfield had the opportunity to review her trial rights?
Yes, Your Honor.
Mr. Chatfield, do you have any questions about your trial rights?
I do not.
Okay. And Ms. Chatfield, do you have any questions about the rights available to you at a trial?
No.
And then finally, I want you both to know you have a right to a hearing that's called a preliminary examination. At that hearing, the court would hear evidence and determine by a probable cause standard whether the crimes alleged were committed and whether they were committed by you. Mr. Chatfield, do you understand your right to a preliminary examination?
Yes.
And Ms. Chatfield, do you understand your right to a preliminary examination?
Yes.
And first, Ms. Chartier, on behalf of Mr. Chatfield, how are we proceeding today?
Mr. Chatfield is pleading not guilty on all counts. We are requesting a probable cause conference date and then a preliminary examination date, with the caveat that we have not even received discovery yet from the Attorney General's office. It's my understanding it is quite voluminous, so in all likelihood we will be asking the court to waive the time period for the preliminary examination.
Okay, very good. Thank you, Ms. Chartier. And Mr. Newberg, on behalf of Ms. Chatfield, how are we proceeding today?
Thank you, Your Honor. We're going to ask the court enter a plea of not guilty as to all counts for Mrs. Chatfield. We, too, are going to be asking for a preliminary examination and probable cause conference. And I've gone over the timelines that are required by law. We're going to be waiving whatever timelines are imposed by the court so we can review the discovery prior to the preliminary examination.
Thank you, Mr. Newberg. So we'll turn to those dates. The court will enter those pleas of not guilty on behalf of Ms. Chatfield and Mr. Chatfield. And the dates that would be set, so the parties know, would be a probable cause conference on May 10th at 8:30, and then a preliminary examination on May 16th at 9 a.m. I want to turn to Mr. Rolston on his position on the defendant's request to waive their 21-day timeline and adjourn these matters out. Mr. Rolston.
Yeah, that's fine, Judge. No objection. Thank you.
Okay, thank you. And Mr. Ralston, in terms of time, how long out, how lengthy of an adjournment should the court be looking at?
Judge, a couple of thoughts. Number one, we're prepared to deliver the first tranche of discovery. Mr. And I'm going to probably mispronounce his name, Mr. Jadranko from my office and our Treasury section is here. Some of the records, and the reason we haven't produced discovery yet is because of, he represents Treasury. I do not. And he represents the Treasury Department of the state of Michigan. Some of the records that we have are tax records. They're the tax records of Chatfield, but still we're under statutory obligation to get a protective order in place before we turn those over. I'll let him address that when the time is right. Once we have a protective order for the tax records, and we also have a protective order now for that we've entered previously for just the general discovery. We'll be prepared to turn over discovery to counsel.
Okay, thank you so much. So would a probable cause conference in June be appropriate? Should I look in June?
Sure. Here's my thought. Let us get discovery to counsel,
Okay.
which I think after today, we can probably get that to them in short order, meaning today or tomorrow, once that protective order from Treasury is entered. And then allow them to survey it, and take a look at it, and then we can come back to the court with their ideas about, when they might be prepared to conduct a preliminary examination. 3 or 4 weeks sounds about right.
Okay, very good. Ms. Chartier, does that sound appropriate to you?
It does, Your Honor. With PCC in June, then Mr. Newberg and I would have a better idea of the length of time that we would need to get ready for the exam, and then we would be in a better position to request a particular date.
Very good. And Mr. Newberg, do you agree?
Yes, Judge.
Okay, thank you. So I'll ask my judicial assistant to look for a date in June for a PCC and a preliminary examination.
We could do June 14th at 8:30 for the PCC.
Okay,
And June 20th for the exam.
perfect. Thank you. So we'll be setting the probable cause conference date on June 14th at 8:30 a.m.
Your Honor, if I may, I apologize. I am scheduled to present at the Great Lakes Legal Conference on Mackinac Island on June 14th, and I believe that's right at the time of my presentation.
Okay, very good.
Possibly June,
June 6th.
How about June
6th?
6th?
6 or 7?
Perfect. June 6th, again at 8:30 a.m. So the parties understand that hearing is held via Zoom. And then the preliminary examination would be June 13th?
13th.
June 13th at 9 a.m. And that would be held in person here at the 54B District Court. So now, Ms. Chartier and Mr. Newberg, I will inquire to your clients as to waiving the 21-day timeline. Are they prepared to do that, Ms. Chartier?
Yes, Your Honor. Mr. Chatfield is.
And Mr. Newberg?
Yes, Your Honor.
Okay, thank you. Mr. Chatfield, I'll begin with you. Have you heard the discussions that the lawyers and I have had?
Yes.
Okay, and so you understand that there's been a request by your lawyer to adjourn the original date that I was going to give you for our next hearings. You heard that, correct?
Yes, Your Honor.
And the reason for that is so that your attorney can receive all the discovery that, of course, she is due, and review that discovery and be prepared for the preliminary examination. Is that your understanding?
Yes.
I want you to know you have a right to a hearing under Michigan law to have your preliminary examination within 21 days of our arraignment today. If I grant the request to adjourn this matter, you will not have that hearing within 21 days. Of course, you still have the right to have that hearing. It will just be set out for a later date. Do you understand that right?
I do.
And you wish to waive that right so I can grant your attorney's request for an adjournment?
Yes.
Okay. Anyone promise you anything to waive this right or force you to do this, Mr. Chatfield?
No, Your Honor.
Is it your own choice?
Yes.
Okay. And then, Ms. Chatfield, similarly, do you understand your right to have this hearing within 21 days of our court date today?
Yes.
And do you wish to waive that right so I can grant your attorney's request to adjourn this matter to a later date?
Yes.
Has anyone promised you anything to get you to waive that right?
No.
Has anyone forced you or threatened you to do this?
No.
Is it your own choice?
Yes.
Okay. The court finds that Lee Chatfield and Stephanie Chatfield understand their right to the 21-day timeline and are intelligently and voluntarily waiving that right. So the court will accept that waiver. There's no objection from the Attorney General, and the probable cause conference and preliminary examination are set at the dates provided. So with all that, the court will now turn to bond. Mr. Rolston, would the people like to be heard on bond?
Nothing really to add, Judge, as to bond, but I do have a question about the scheduling.
Sure.
I know that you scheduled a preliminary exam for June 13th. I mean, is that a placeholder, or are we going to exam on that date?
Hearing from the parties, it sounded more like a placeholder, just because the defense had noted that it would have a better sense of how their review of the voluminous discovery in this matter is going, but we are going to set that, and I trust that the parties will be in touch with each other as to discovery and how the review of discovery is going.
Great, thank you.
Okay, absolutely. And then on bond, nothing to add, Mr. Rolston?
The only thing I'd ask is, I would ask the Chatfields turn over their passports. Pretty standard and typical, and we'd ask that the court require that.
Okay. And that is because of a fear of non-appearance or flight?
Yeah, exactly, Judge. Thank you.
Okay. I just have to say that is not at all typical in this court's practice. I mean, unless there is a specific, if there's a circumstance surrounding a particular defendant. So I would just, if you would like to elaborate on what it is about Lee Chatfield, Stephanie Chatfield, that would require the court to have them surrender their passports. I don't know.
I mean, I guess my thought is that whenever anybody's charged with, as in Mr. Chatfield's case, with conducting a criminal enterprise, that's a 20-year felony, prison guidelines. It's a serious offense, and I understand what you just said about it's your practice to not require that, but and typically in the cases that I handle, that's what I've seen judicial officers and many times ask the defense to turn over the passports during the pendency of the case.
Okay.
I think the matter of fact, I think the Chartier mentioned the other day that they were in Europe recently. So, up to the court, and those are my thoughts.
Okay, so it's the serious of the charge, and perhaps it sounds like the Chatfields, had the means to travel out of the country.
All correct, Judge.
Okay, thank you. Ms. Chartier, would you like to be heard on bond?
Thank you, Your Honor. Mr. Chatfield is not a danger to the community. He has absolutely no criminal history whatsoever, and these are serious crimes, but they are financial allegations. As it relates to him being a flight risk, it has been almost 2.5 years that Mr. Chatfield has had to live under the umbrella of allegations being made. His allegations, his life have been in the media regularly. He has been wrongfully maligned. There's been speculation, rumor, innuendo, false claims. Throughout all of that, he has never fled, not once. If he were going to flee, he would have done it by now. He would not have asked the court's permission to travel out of state. He would have left. He has 5 young children. He has no history of failure to appear in court because he's never had to be in court for any sort of criminal offense. And after 2.5 years of being falsely accused, he is looking forward to his day in court and fighting this. Mr. Chatfield is not a flight risk at all. At our last hearing this week, Mr. Ralston asked that Mr. Chatfield be treated like any other defendant, and I'm asking for the same. Similarly situated defendants have been required to not post a bond, but have had a personal recognizance bond, and that's what I'm asking on behalf of Mr. Chatfield. He is ready to fight these charges, and we will fight these charges whenever we need to appear in court.
Thank you, Ms. Chartier. Mr. Newberg, would you like to be heard on bond on behalf of Stephanie Chatfield?
Thank you, Judge. Judge, Ms. Chatfield is in the same situation as Mr. Chatfield. I think I brought it to the court's attention at the last hearing. During the 2 years investigation, she was contacted, or I was contacted by law enforcement. She went and spoke with law enforcement on different matters. She always appeared. During that time, she also left the state and she also left the country. But she also, without having any requirement to do so, let me know when she was leaving and when she was returning, knowing that there was an investigation going on. That's also the same situation here, Judge. She called and let me know over the weekend that they were headed to Kentucky, that they had pre-booked the flight. And we took the step of notifying the court even before an arraignment to allow them to travel out of an abundance of caution. And here they are on time today. She has no criminal history. She is working as a teacher. She has 5 kids. And so I'm going to ask the court to give a PR bond and set this matter, which the court already has, for a preliminary examination, and we can see how the facts fared out at that point.
Thank you,
Judge,
Ms.
real quick,
Absolutely.
I just noted Mr. Newberg indicated that they're flying to Kentucky. I think Ms. Schubert, that's probably a point we should clear up.
Yeah,
They drove. If I said flight, that's my fault. They drove.
Okay, thank you. Very good. So, turning first to Mr. Chatfield, both Mr. and Mrs. Chatfield, were you both able to hear what the lawyers told me in regards to bond?
Yes.
Yes.
Okay, thank you. So as the parties all know, under Michigan law, the court may consider 2 factors in making a bond determination. Those factors are 1, whether the defendant will appear for all court dates, and 2, whether the defendant poses a risk to public safety. The court agrees with the defense counsel, and I don't think that there's really much objection from the Attorney General that neither factor in these cases is triggered such that any sort of money bail bond is allowed in this case, and any concerns that the court has as to either of those factors can be addressed through bond conditions. So, Mr. Chatfield, turning to you, your bond is set at $100,000 personal recognizance. That means that you do not have to pay any bail money at this time. I'm releasing you because I trust that you will come to court as directed and you will follow my bond conditions. Am I right about that?
Yes.
And then Ms. Chatfield, your bond is set at $15,000 personal recognizance. And again, I agree with your attorney that there's good reason to trust that you will come to court as directed and you will always comply with my bond conditions. Am I right about that?
Yes.
Okay, thank you. And then with that, your conditions, and this applies to both defendants, are as follows. You must appear as directed. You may not leave the state of Michigan without permission of this court. You must not commit any crime while you are on bond to this court. Given the information provided by the Attorney General, the court is ordering that Mr. and Ms. Chatfield surrender their passports to the 54B District Court, and the court will provide you instructions on how to do that and comply with that order. I wanted to address the parties. Often there is a no contact order that is ordered between co-defendants. Obviously, the circumstances of this case would make a no contact order difficult. And so I'm clear, the reason for the no contact order is to preserve the integrity of the proceedings. Mr. Rolston, do you have a position on a no contact order between the co-defendants?
No, I think that'd be very cumbersome.
Agreed. Ms. Chartier, anything on that?
A no contact order would make it incredibly difficult for them to parent and to be married because they wouldn't be able to speak to one another. So we would ask that that not be imposed.
Okay, and Mr. Newberg?
Nothing additional to add,
Okay,
Judge.
so for the reasons stated by the attorneys, that will not be imposed in this matter. Ms. Chatfield and Mr. Chatfield, your bond will be overseen by the 30th Circuit Court Pretrial Services Division. The court will provide you and your attorneys with their contact number, and I'm ordering that you must contact pretrial services today, May 2nd, by the end of the business day. Mr. Chatfield, is that understood?
Yes, Your Honor.
And Ms. Chatfield, do you understand that as well?
Yes.
Okay, thank you very much. And like I said, we'll make sure that you get the phone number instructions on how to contact pretrial services. Next, we need to address a fingerprint order. The court understands that the parties, the defendants, need to be fingerprinted because this is an Attorney General case. Mr. Ralston, the court has ordered that the defendants must go to a location to be determined by the Attorney General to have one of their special agents fingerprint the defendants, and has ordered that this must be done by May 10th. Any comment on that, Mr. Ralston?
Does that include the DNA, the biometric collection too, Judge?
It does not. It's just a fingerprint order.
I think the court rule, let me check here, I think it also requires the DNA too.
We can address that if you wish to, but we all know that fingerprints are required. So as to the instructions to the defendants that the location will be determined by the Attorney General, is there any other instruction that the court should give the defendants?
I was just, it's 104 E6 is the court rule that I'm thinking of that requires the DNA collection, but no, nothing else to add, Judge, thank you.
Okay, very good. So, Miss Chatfield, I have your fingerprint order here. I'm signing that. So you'll have to stay in good contact with Mr. Newberg, who will help facilitate that these fingerprints get taken. This is just a standard part of every court case, and this, again, order must be complied with by May 10th. Understood?
Yes.
Okay, and same for you, Mr. Chatfield. Do you understand this order?
Yes.
Okay, very good, thank you. So, next the court wanted to address that it has received a travel request from each defendant, and note that at a hearing of Tuesday of this week, the parties notified the court about a pre-planned trip that Mr. and Mrs. Chatfield had planned out of state. The court concluded that that trip would not impact the two factors that it may consider in making a bond determination, and instructed the defendants to complete a travel request that all defendants who appear before this court must complete and use to request permission to travel out of state. So I have received that request from both Lee and Stephanie Chatfield. Ms. Chatfield, your request states that you would like to leave the state on May 1st, returning on May 6th, and for the purpose of travel, it explains that you will be accompanying your husband to Louisville, Kentucky. A portion of the trip will be for my husband's business meetings, and the other portion will be recreational in nature. And then you provided an address where you would be staying. Ms. Chatfield, this is signed and dated, and it is noted on the form that if granted consent by the 54B District Court to leave the state of Michigan, that you agree to depart and return on the dates and times indicated above, and that you understand that failing to comply with the terms of this request could result in a violation of bond conditions. Ms. Chatfield, is all the information on this form correct? And you signed and dated it?
Yes.
Okay, and then you understand the consequence of not complying with the information provided, correct?
Correct.
Okay. And Mr. Chatfield, I received your request, which informs me that you would like to leave on those same dates, May 1st, returning May 6th, and that you would be traveling from Michigan to Louisville, Kentucky by car, and you provided an address where you would be staying, and that it tells me that you're traveling for business and recreational purposes. And Mr. Chatfield, under the information that you agree that you will depart and return on the dates and times indicated, and that you understand failing to comply with the terms could result in a bond violation, you signed and dated that. Mr. Chatfield, is this all accurate information?
Yes, it is, Your Honor.
And did you sign and date this form?
I did.
Okay. And so as to these requests, Mr. Rolston, any comment on behalf of the Attorney General?
Only that I thought the information the court received on Tuesday was pretty thin. And what I mean by that is, I mean, even the name of the consulting firm, Mr. Chatfield, and the exact reason for the travel. I mean, I didn't feel like there was a lot of detail given, is I guess what I'm saying. And again, I asked the court to treat him like anybody else. And the nature of the travel to me, again, the description by Ms. Chartier was she imagines they're going to be doing a lot of things, but didn't really provide the court with a lot of detail. I mean, it sounds like they're going down to the Kentucky Derby.
I thought that was established on Tuesday also. Ms. Chartier, anything? Well, first of all, say in looking at Ms. Chatfield's request, that is a detailed enough and typical normal request. I do find that Mr. Chatfield's "I am traveling for business and recreational purposes" is more vague than the court would typically receive, and if as the court is more is used to a request that might say, "I'm traveling for an educational conference to this state and this date and time, and this is the professional organization," and often people would let me know if there's any kind of family emergency. Of course, they're traveling for a funeral of their grandparent, and they will be going from. So I do get more detailed information. Business and recreational purposes is quite vague. Ms. Chartier.
Thank you, Your Honor. So Mr. Chatfield and Mrs. Chatfield are going to Lexington, Kentucky, or excuse me, in Lexington and Louisville, Kentucky. I think they passed through Lexington to get to Louisville. They will likely go to the Kentucky Derby. I think the level of specificity that Mr. Ralston is looking for doesn't exist when two adults are traveling. They probably will be going to dinner. They'll probably be going for walks. They'll likely be going to the Kentucky Derby. But is their entire day mapped out from the time they wake up to the time they end? No, they don't. And the reason why I say it's likely that they will is they have 5 young children. So if a child gets sick, they're getting in that car and coming back. If somebody else gets a cold or gets COVID, they're not going to the Kentucky Derby. So there are so many life events that come in that it is impossible to list an agenda. Mr. Chatfield runs a consulting firm. Mr. Ralston in the AG's office knows that because they've been looking at the details of his life for the last 2.5 years. He's going down there to meet with potential clients. I think to have to specify who they are is such an infringement on his privacy that I would absolutely, argue against that. He is going to Louisville, Kentucky for his business. They are going to also enjoy themselves while they're there. He is conducting himself in the exact same way that he has the last 2.5 years. He's had to travel for work. His wife has frequently come with him, and then they go home. This is no different than any other trip, except for the fact that now he is under a court order.
Okay, thank you. Well, I appreciate, Ms. Chartier, the additional information, and the information you provided would suffice to have this be a normal travel request that the court is accustomed to. So they are traveling. The plan is to go to the Kentucky Derby. There will, of course, be other recreational events that may happen along the way, but also that Mr. Chatfield has a consulting business, and he will be meeting with clients. I don't need to know the client's names, of course. I don't need to know restaurants or anything, but that is helpful and, like I said, more typical a request that the court would be comfortable granting. So with that additional information, the court is granting the requests. Ms. Chatfield, I'm signing your request right now and approving that, and same for you, Mr. Chatfield. So moving forward, and the court is anticipating that this may come up again, just so the parties understand, as is the court's typical practice, this is the travel request form that is used for all defendants. I think I've made clear the level of specificity that the court is accustomed to. And Mr. Ralston, certainly if the Attorney General would like to be heard on these travel requests, particularly if they're quite frequent, the court would be inclined to just say that we will schedule a review of these travel requests. You know, those reviews would always be held on Zoom at the convenience of the parties, and the AG could be heard.
Thank you, Judge. We'd ask for that.
Okay, so that's how all the parties understand that is how we will move forward. Very good. So I think that takes us to what I see as our last order of business, which the court has a motion before it from the Attorney General's office. Mr. Ralston noted this motion that was filed on behalf of the Department of Treasury. Are the parties ready to address these motions today? Mr. Ralston, or I think it's, I want to greet you. Is it Mr. Bobas?
Yes, Your Honor.
Okay, nice to meet you. Are you ready to proceed today, sir?
Yes, Your Honor.
Okay, and Ms. Chartier, have you received and reviewed this motion, and would you like to proceed on it today?
Yes, we have received it, and yes, proceeding today is appropriate. Thank you.
And Mr. Newberg?
Yes, Judge, we've received it, we've gone over it, we're ready to proceed.
Thank you. So, Mr. Bobas, on behalf of the Department of Treasury, this is your motion. Anything you would like to state for the record?
Just briefly, to Your Honor. So last week Friday, I filed the motion brief in order for the disclosure of defense tax information according to MCL 205.281F. And in Michigan, taxpayer information provided to Treasury may not be released without specific statutory authorization. And 281F governs the proper release of taxpayer information, and only under limited circumstances, including a court order, can Treasury release taxpayer information. Thus, Your Honor, an order is simply needed to facilitate the exchange of documents in this case.
Thank you so much, Mr. Bobas. I appreciate that. Ms. Chartier, any objection to this motion?
No, it's my understanding, I just want to make sure I state this on the record, because for me, there was some lack of clarity in the motion that was filed. My understanding is these tax documents have already been released to the Attorney General's office. So, for example, Mr. Ralston and his team have them, and then the order just governs the release to the defense. So if that is what the motion entails and that's what the government is requesting, then we don't object to that. If it were releasing documents beyond what Mr. Ralston and his team have received, then we would be objecting to that.
Mr. Bobas.
So the order covers both documents that are currently in the possession of Mr. Rolstein, but it also address future documents that may be needed to adjudicate this case. So, for example, if Mr. Rolstein needed a Treasury employee to testify, this order would also cover that employee as well, Your Honor.
I noted that in the motion. Does that answer your question, Ms. Chartier?
It does to an extent. So if an employee has to come and testify as to what documents have already been disclosed, then I have no issue with that. But if it covers future documents, then I believe that should be addressed on an ongoing basis. I don't think that we should have a blanket order that whatever Mr. Ralston believes he needs from Treasury to prosecute this case, he should get, and we're agreeing to that. I think if there are additional documents, we can deal with that in another motion before the court.
Okay. Mr. Newberg, would you like to be heard on this motion?
Yeah, Judge, same comments that Ms. Chartier just made. I'm fine, as long as the order just governs documents that have already been turned over. My client is not consenting, to any additional documents to be provided to the Attorney General's office from the Treasury as the investigation continues. I think one of the things that was clear when the charges were announced is that the Attorney General's office is still investigating this case. So if it's going to cover documents that are currently in the possession of the Attorney General's office and we need them as part of the discovery, great, I have no objection. If it's for additional documents, then I'd like the court to table that issue, set this for a hearing on a different day, and we can address it on a different day, just as to the documents that have not already been provided to the Attorney General's office.
Okay. Mr. Bobas or Mr. Ralston, is there a way to limit the order that's been proposed to the information, the tax information already in the possession of the Attorney General's office?
I don't represent Treasury, so I'm going to be, I'm going to let Mr.
You'll
Bobas
defer to Mr. Bobas. Okay, Mr. Bobas.
Yes, Your Honor. I mean, certainly, we could limit the order. Again, in the interest of judicial economy, the order simply protects Treasury and its agents from criminal penalties. It's really a non-controversial order, but it is up to this court, Your Honor.
Okay. Mr. Bobas, you've heard what the defense attorneys, their concerns or their objection to the order. We can set this for a hearing and we can adjudicate this. This would, of course, be it would delay disclosure, which the court is interested in having the documents disclosed as soon as possible. So if there is a way that we could add language or strike language of this order to limit, to satisfy the defendant so we could have the tax records and Treasury given the protection it needs as soon as possible. So is there a way to add, I'm looking on page 2 of the proposed order, if we all would want to look there. And it states tax-related information relevant to these proceedings. Is there a way that we could limit the tax-related information already obtained, already in the possession of the Attorney General's office related to these proceedings?
We could, Your Honor.
Okay. Ms. Chartier, would that satisfy your objection?
Yes, Your Honor, as long as it is only documents currently in the possession of the Attorney General's office, and there's certainly no waiver of future documents, that does cover our concern.
Okay.
Our concern, quite frankly, in this regard is not judicial economy, it's protecting Mr. Chatfield's rights.
Understood. Would you like to propose language, Ms. Chartier?
I think that if the Attorney General redrafts the order with some proposed language, we could take a look at that, and then that can be submitted to the court. I also don't think this really needs to hold up the items that are not tax related that the Attorney General's office can disclose to us. They do have a protective order signed by the court. So those documents can be forthcoming, and then as we work out the language, the tax documents can follow.
Okay. Mr. Newberg, do you agree with that and would like to proceed accordingly?
Yes, Judge.
Okay. Mr. Bobas, would you be willing, please, to work with Ms. Chartier and Mr. Newberg to draft some language in the proposed order that could be agreed to, and then that would be submitted to the court at a later date?
Yes, Your Honor.
Okay. Thank you, Mr. Bobas. Anything on that, Mr. Rolston?
We're going to be cautious about, we're not going to turn over any discovery until this issue is resolved. Because we're going to be cautious about, in case there was a document in a file that, we missed and then we're in violation of the statute. So we'll wait till this issue gets resolved. I'm sure it'll be resolved very quickly between the 3 lawyers. And then we'll turn over discovery after that.
Okay, very good. So that definitely does make this a priority for the attorneys. Understood?
Yes.
Okay.
Yes, Judge.
Thank you so much. So with all that, we've accomplished a lot today. Mr. Rolston, do you have anything else for this record?
No, thank you very much, Judge. It's been a pleasure.
Thank you. Ms. Chartier, do you have anything else for this record?
I do, Your Honor, just 3 things. So for future travel requests, if there is a Zoom hearing, will Mr. Chatfield need to attend by Zoom, or will it be conducted the same way it was earlier this week with just the lawyers?
Right. So the Mr. and Mrs. Chatfield would be required to attend, and the reason is because it's their request, and of course they are in the possession of the most detailed information. They were not required to attend on Tuesday because they hadn't been arraigned by this court yet. So now they are arraigned, the case is officially started, they are parties to this case, they are fully apprised, they have met the court, and so we'll proceed, and their appearance would be required.
Thank you. And then for the passport surrendering, is there a particular date that the court would like that to be surrendered to the court by? And what I was anticipating was Mr. Chatfield will provide that to our office, and then we can turn that in.
Very good. Thank you, Ms. Chartier. Since I understand the Chatfields will be returning on May 6th, so could we have the May 7th be an appropriate?
So, and that is a little bit of a challenge because they live a few hours away, so they would need to go up north, get their passport, and then drive back to us. If possible, if it could be by May 10th or May 17th.
Okay, May 10th.
Okay. And then the fingerprinting through the Attorney General's office, I just would like to place on the record, I would ask Mr. Ralston to contact me so that we can facilitate that. And that way I will ensure that Mr. Chatfield gets that done. And then the other, for contacting pretrial services, will that information be sent directly to me and I will forward that to Mr. Chatfield?
It will. Thank you, Ms. Chartier. You are probably familiar, but you know, it's going to be the phone number that we use all the time in every felony case. Thank you, Ms. Chartier.
Then I can provide that to him now. Thank
Okay,
you.
perfect, thank you. Mr. Newberg, anything further for this record?
No, Your Honor, thank you.
Okay, very good. Thank you all for your appearances today. Lee and Stephanie Chatfield, good luck to you, and we'll see you again soon. That's all for this record. Thank you.
Thank you, Your Honor.
Yes.
Have a great day.
You too.